You're on live. Right. You're on live. Today we are discussing the law on negotiation.
Are you audible?
Am I audible, sir? Hello? Hello? Am I audible?
Is he audible? Please respond. Is he audible?
Yes. Today's lecture is on Negotiable Instruments Act of 1981. Negotiable Instruments Act also was a species of the Indian Contracts Act. The word negotiable means transferable, easily transferable. That is called negotiable. Then instrument. Instrument means anything in writing is what is called an instrument. So that has a monetary value and are transferable. So in the negotiable instrument has been defined as anything that has a monetary value and are transferable. That means there must be a money value given to an instrument which can be negotiated, which can be transferred, which can be dealt with. That is called a negotiable instrument. Then it includes the entire, that is checks, bills of exchange, and promissory note, but excludes undies, a common means of monetary transfer prevalent in some parts of India. The mode of transaction, the transfer, is under the NA Act. If they can be transferred, endorsement, or delivered, it must also give the right to sue to the holder of if there are some means of discrepancies in the transaction. Then, similarly, there are other negotiable instruments in other countries. Singapore has devised its own law. Here, the sum and substance of this paragraph is that the Negotiable Instruments Act was passed in the year 1881. It was one of the earliest enactments that was passed during the time of the English people. And negotiable instrument, the meaning of negotiable instrument is that is, it is based on monetary transactions intercede the parties. And negotiable means it is transferable. Instrument means anything that is can be transferred, which involves a monetary liability or creates a monetary liability, creates a pecuniary liability, or concerning money, it is called a negotiable instrument. And here, negotiable instruments are of various types. One is the prominent among them is promissory note, bill of exchange, and checks. Here, as far as every country is concerned, they devise their own laws and they have got their own laws called the Negotiable Instruments Act. But the act which we are dealing with is the Negotiable Instruments Act as prevalent in India and passed in 1881. Here, it says that the mode of transfer has to be considered under NA Act if they are transferable, endorsement, or delivery. It must give right to sue to the holder of if there are some means of discrepancies in the transaction. And similarly, there are other negotiable instruments in other countries. Singapore has its own act. So the law which we are now discussing is the law that is prevalent in India, the enactment that is prevalent in India, the enactment that is implemented in India. It is called the Negotiable Instruments Act of 1881. The word negotiable instruments, again I define, negotiable means transferable. Instrument means anything contained in writing is what is called a negotiable instrument. That's why in the earlier classes also I told you, instrument has got different connotations. As far as instruments are concerned, people from different spheres of activity have got their own instruments to carry out their work. But as far as monetary transactions are concerned, as far as business transactions are concerned, as far as creditor debtor relationship is concerned, the documents which support the passing of consideration from one person called the creditor to another person called the debtor, and they are which involves a monetary liability. Monetary means liability in terms of money, and which can be easily transferable, is what is called a negotiable instrument. Negotiable instruments is of three types. One is called a promissory note, another is called a bill of exchange, and another is called a check. Then any instrument that has a financial implications is transferred in the negotiable instrument side. So as far as a negotiable instrument is concerned, be it a promissory note, be it a check, be it a bill of exchange, it can be easily transferable. That means the very essence or ambit or object of negotiable instrument is to see that monetary liability, pecuniary liability is honored, and the relationship of creditor and debtor is established by a particular document. And that document is what is called a negotiable instrument, or a document that can easily be transferred by endorsement. Endorsement bole to, that is what can be transferred, and what can be, suppose you have it, you can transfer it to some other person. It can easily be negotiated. This is what is called a negotiable instrument. Here, the conditions are freely transferable by delivery. If the name of the seller of the instrument is defective, it should not afford a person of the instrument by trusting them. Here it is said, the person who holds the instrument, be it a promissory note, be it a bill of exchange, be it a check, is supposed to be a holder in due course. That means a relationship of a creditor and debtor is established by a negotiable instrument. And negotiable instrument, the essence of negotiable instrument, the object of negotiable instrument is to afford a proof to the person who has lent money, a person the person who has lent money, or a person who is dealing with a business transaction, and the document which supports passing of consideration or the money transaction is evidenced by negotiable instrument. So, negotiable, the word negotiable itself means, the dictionary meaning is which can easily be transferred, or which is capable of being transferred by what modes, sir? By delivery, by endorsement, or by any other means known to the business world. So, a negotiable instruments act plays a very important part in the commercial world. It is purely meant on trust and confidence, so that either party, be it the creditor or be it the debtor, are bound by the money transactions which they have intercede. So that is the scope and object of the Negotiable Instruments Act. Then holder of a negotiable instrument transfers name. Then one thing you must remember, sir, there is a maxim in the Transfer of Property Act that nemo dat quod non habet. That is, no man can pass a better title than what he himself has. Any person can acquire a negotiable instrument from a seller who has not possessed it, but it must be for bona fide reasons. So the reason is, sometimes people lose their patience. People don't want the waiting period. So that is the reason. What they do is they transfer it, they endorse it, and they make it over to some other person and give a notice to the debtor, from tomorrow I am not the creditor, she will be the creditor, and whatever money you have to pay based on the instrument which have endorsed or which have made it over, which have transferred to the transferee, please pay the money to that person. So in other words, an instrument which it can be negotiated, an instrument which evidences a pecuniary transaction, and an instrument which depicts a money transactions, intercede the parties, is what is called a negotiable instrument. And please bear it in mind, the privity of contract does not apply as far as NI Act is concerned. Suppose I am the creditor and you are my debtor. What I do is, I don't have the patience to pursue the payment of money. What I do is, I endorse it, I transfer it, I give it to some other person. Please take all the necessary action that is possible. So the essence of a negotiable instrument is, it is easily transferable. You can easily make it over to some other person. Only condition is, that you must give notice to the debtor that I've already assigned the promissory note, I've already endorsed the promissory note, I've already transferred the promissory note. From tomorrow onwards, she will be your transfer. She will be the person who will be your creditor, and whatever money you have to pay me, you pay to that person. This is what is called a negotiable instrument. Are you able to understand, please? Again, I repeat, a negotiable instrument, the essence of a negotiable instrument is it evidences a monetary transaction between the creditor and the debtor. It is an instrument or it is a document which evidences the payment of money and the amount which is due by a person, or it establishes the relationship of a creditor and debtor. And the object of negotiable instrument is it is easily transferable, and the person who holds that instrument is a holder in due course, and even if he's not a party to the document by endorsement, for all practical purposes, he becomes the creditor. So, and prompts at the NI Act says negotiable instruments are of three types. One is called a promissory note, one is called a bill of exchange, and another is called a check. But different countries have different laws. And as far as Singapore and other countries are concerned, they have their own laws. Our Indian laws do not apply to those countries because our Indian laws apply only to our country and not to any other country. Then this maxim, nemo dat quod non habet, no man can pass a better title than what he himself has, then it must be for bona fide reasons. Suppose I transfer the negotiable instrument, then it must be for bona fide reasons, and it should be for reasons best known. The transferee will have to be, the debtor has to be given notice that an assignment has taken place, a transfer has taken place, and the creditor has changed. Some other person has come who has come into possession of the negotiable instrument, be it a promissory note, be it a bill of exchange, or be it a check. In that particular case, the maxim nemo dat quod non habet does not apply in those contingencies. This is the introduction as far as the Negotiable Instruments Act of 1881 is concerned. Now we go one by one, for especially Section 4 of the NI Act, which defines the various terms. The first term that is defined is a promissory note. Promissory note, if you literally translate it to Telugu, it means pramana patram. Pramana patram is, that is what promise you give to another person is what is called a promissory note. And promissory note emanates from a money transaction between a creditor and a debtor. Please remember, if you see a printed promissory note, it comprises of two parts. One is called the promissory note, and on the right side, you have a receipt. Then the question often arises, sir, what is first? Whether it is a promissory note that is first or a receipt is first. Please remember, there is a relationship of creditor and debtor. Who pays the money and who receives the money, sir? It is the creditor who advances money. It is the debtor who receives the money. So the creditor is called the promisor, and the debtor is called the the debtor is called the promisor, and the creditor is called the promisee. There is a relationship between them regarding money or payment of money, money lent and received, money had and received. So here the question often arises in most of the competitive examinations. Also, they ask, sir, which is first? Whether the receipt is first or the promissory note is first. Please remember, what is the wording of a promissory note, sir? On demand, oblique order, I, A, son of so and so, age so and so, resident of so and so, do promise to pay Mr. B, son of so and so, resident of so and so, a sum of rupees so and so, by way of hand loan within so and so days or whatever it is, and beneath it he signs on a revenue stamp. Please remember, a promissory note has to be properly stamped. An unstamped promissory note is a nullity. It cannot be enforced. So revenue stamps are how much value I should affix, sir? It is your own choice, sir. Either 1 rupee or 2 rupees or 10 rupees also you can affix, because after all, revenue stamps will not cost you more. Then, sir, the other part of it, you have got the receipt. Receipt has a date, and I as a debtor, I so and so, so and so, so and so, resident of so and so, do hereby admit the receipt of rupees so and so by way of hand loan from Mr. B on so and so date. Then there is a revenue stamp also affixed to the receipt. Then the question arises, sir, which is first? Whether the receipt is first or the promissory note is first. But please remember, receipt is first. First you receive the money, sign the receipt, and in token of having received the money, you accept your commitment, you accept your liability, and you also say, I'm indebted to you, Mr. Creditor, and I so promise to pay that money on a particular date. Then with the revenue stamp, please remember, as far as the revenue stamp is concerned, even if your receipt is not properly stamped, let us say revenue stamp is not affixed, it can always be validated by paying the deficit duty and the penalty. Normally, the penalty is 10 times the amount that is levied for a revenue stamp. That is, suppose it is 2 rupees or 1 rupee, 1 into 10 will be 10 rupees, and that 10 rupees which you have, or 1 rupee which you have not affixed, that amount will be collected. But as far as promissory note is concerned, promissory note has to be properly stamped. Without proper stamp, a promissory note is not enforceable under the law. So that is why I said, what is the wording that is used, sir? On demand, oblique order. I so and so promise to pay Mr. B, son of so and so, resident of so and so, a sum of rupees so and so, taken by me by way of hand loan for my business commitments. Then he puts his signature. But first and foremost is, I told you, receipt is first and promissory note is later. But if you see most of the printed promissory notes, I think most of you are advocates. You know, there is a column down also, security. There is a word used, security. But please bear it in mind, if it's going to be only a demand promissory note, don't fill up that word security. If you fill up that word security, it becomes a bond and it is not a promissory note. So, as far as possible, you strike out that security column and don't fill it up. Because some people have an impression, suppose a third party assures payment, guarantees payment, or he stands as surety, or హామీ అంటారు చూడండి, that is in case the debtor does not pay, I will pay, and he gets involved in the transaction. Then in that case he becomes a guarantor or he becomes a surety. At the most it becomes a surety bond. If it becomes a surety bond, please remember it's very, very disastrous. Why? Because if suppose, let us say, I advance a sum of 50,000 towards loan to you, if you fill up the security column, you have to pay, it is a bond, it is a surety bond. Then the stamp duty which you pay is 3% of the amount mentioned in the document. So please remember, it's very, very disastrous to fill up the column of surety or security rather. So that is the reason why, as experienced and clever advocates, we type the promissory note and receipt. We don't rely on the printed promissory notes which is available in the market. Are you able to understand, please? Here, taking it in consonance with the NI Act, this promissory note, no doubt there's a relationship of creditor and debtor, evidencing a monetary transaction inter us, and this promissory note, I can always make it over, I can always negotiate it. On the reverse of the promissory note, what I do is made over and transferred to Mr. C, son of so and so, resident of so and I put my signature and also issue a notice to the debtor. Sir, I've made over the promissory note, I've assigned the promissory note, I've transferred the promissory note, and I've negotiated the promissory note, and by endorsement, I've made it over to C, and from tomorrow onwards, he will be your creditor, and whatever amount you have to pay me, you pay to that particular person. That is why it is said, that is the beauty of promissory note, sir. That's the beauty of a negotiable instrument. A negotiable instrument, we cannot have rigid rules. We cannot have rigid rules by saying, I alone should, privity of contract says, I alone should file a suit, I only should initiate court process, I alone should give a notice, I alone should take all steps possible to recover my money. No. Negotiable Instrument Act says, I can endorse it, I can transfer it, I can assign it in favor of whomsoever I like. And on the reverse of it, I endorse, I say, I so and so, hereby endorse this I transfer this promissory note or assign this promissory note to Mr. C, resident of so and so. And I put my signature and put my date also. But I have to give notice to the debtor saying that assignment has taken place. I am no longer your creditor. C will be your creditor. Whatever amount you have to pay me, please pay to C. That is what is called negotiated or transferred by way of endorsement. Are you able to understand, please? This is as far as the promissory note is concerned. But the bankers, normally, sir, the ordinary promissory note consists of two parts. One is called the promissory note and another is called a receipt contained in a single paper. But as far as the bankers are concerned, they use the word demand promissory note. They use the word demand promissory note. If you have studied the Contracts Act, there is a clause called what is called liability of a surety is coextensive with that of the debtor. That's a cardinal principle of the law of guarantee. Here, what I do is the banker what he does is the debtor executes the document, executes the promissory note in favor of the guarantor. The debtor executes the demand promissory note in favor of the guarantor. And on the reverse of it, the guarantor transfers it or makes it over to whichever bank he likes. That is by endorsement. On the reverse of it, the bank gets the right. Bank is not a privy to the contract. Bank is nowhere concerned with their monetary transaction. But here, what happens is the debtor puts his nose over his neck and says, I am liable to the guarantor. And on the reverse of it, by endorsement, when the guarantor makes it over to the bank, both the debtor as well as the guarantor become jointly and severally liable to the bank. This is called a demand promissory note. Demand promissory note is nothing but a single sheet. There is no receipt in that, but only by endorsement, only by transfer, the debtor executes it in favor of the guarantor, and the guarantor makes it over to the bank by assignment, by handing it over to the bank. Here, what happens, sir? The debtor as well as the guarantor become liable because the debtor is answerable to the guarantor or the surety, whatever you may call, and the surety or the guarantor making it over to the bank by endorsement on the reverse that I've endorsed it in favor of the bank becomes a creditor for all practical purposes. So the monetary liability arises not only between the debtor and the creditor, but ultimately both the debtor and the creditor become liable to pay the money jointly or severally to the bank because of the endorsement or because of the assignment or because of the delivery of the document and delivery of the document to the bank. Then in that case, it's a triumvirate. Who are the debtor, guarantor, and the endorsee, the person in whose favor the endorsement is made. That's how the bank tries to protect its interest. Please remember, as far as bank is concerned, they don't follow the printed promissory note. Promissory note and receipt, they have only got one document called demand promissory note. On demand, I, so and so, son of so and so, do hereby pay a sum of rupees so and so to the guarantor whose name is mentioned, and the guarantor on the reverse of it endorses it, hands it over, delivers it to the bank. And that's how a triumvirate relationship exists. That is between the debtor is answerable to the guarantor and the debtor and guarantor. The guarantor by endorsement or the reverse, when making it over to the bank, both the guarantor and the debtor are answerable to the bank. That's why there's a subtle distinction between a promissory note and a demand promissory note. Please remember in promissory note, if you see the wording on demand, oblique order, on demand, oblique order, that means whether a demand or not, or I order payment, then the creditor and debtor relationship is there. That's an ordinary promissory note. But demand promissory note is the debtor executes the promissory note in favor of the guarantor, and the guarantor makes it over to the bank by endorsement or the reverse, transfers the monetary liability to the bank, and then conjointly the debtor is answerable to the guarantor, and the debtor and guarantor put together are answerable to the endorsee, that is the banker. That's how the relationship is brought. Are you able to understand, please? So the wording that is used by a banker is a single sheet that is called demand promissory note. Of course, both mean the same, but in a promissory note you don't have that. I told you also that security column should not be filled. Only there's a relationship of creditor and debtor only between the promisor and the promisee. But if it is endorsed, if it is transferred, if it is given to a holder in due course, then the holder comes into the picture. Then in that case, the holder has got the right of proceeding as the debtor what the creditor would have done. So in other words, a negotiable instrument means what gives rise to a pecuniary liability, monetary liability, or money liability by the promisor to the promisee. It is called a promissory note. And please bear one thing in mind, sir, that when you put the date on the promissory note or on the receipt, don't have any interpolations, don't have any corrections, don't try to strike off anything. because sometimes it vitiates the document itself because it may amount to what is called material alterations. That is the reason the bankers are very, very careful, especially as far as demand prompts and notes are concerned. Please remember, no banker writes it with pen. He puts the rubber stamp there. Why? Because the date is put there, that the date is clear and no one can alter it. So you shall not alter the prompts or note. You shall not make any interpolations in the prompts or note. You shall not make any additions in the prompts or note. You shall not make any deletions in the prompts or note. You shall not make any overwriting in the prompts or note. The promisor should be definite, correctly spelled, correctly mentioned. The promisee should be correctly mentioned. And also, one thing you must remember is the ink which you use as far as the promisor note or receipt is concerned, it's either blue ink or black ink. The same ink has to be used. Once the refill is over, you change over to blue ink and then write it. Please remember, sometimes the promisor note gets invalidated. So, put it in short, section 4 says a promisor note means what is payable on demand or order by the debtor to the creditor, by a promisor to a promisee, covered by a receipt on demand or order, a particular sum of money duly stamped. It is called a promisor note. And promisor note, printed promisor note, again I repeat, it comprises of two parts. One is called the promisor note and another is called the receipt. Please remember, no one is a fool to execute a promisor note without receiving the money. First, you receive the money, and since you have received money, you promise to repay it. That's what the promisor note is written. So, the word that is used in an ordinary promisor note is on demand, oblique order. But as far as the demand promisor note is concerned, what is followed mostly by the banks is the debtor executes the promisor note in favor of the guarantor, and the guarantor endorses it in favor of the bank by handing over the document, and that's where a triumvirate relationship exists. The debtor is liable to the guarantor, and the debtor and guarantor joined together are liable to the endorsee, are liable to the bank. So by endorsement, by transfer, by assignment, a demand promisor note can be drafted. And that is the reason why the bank has only one single paper on which the demand promisor note is normally written. Please bear one thing in mind, as far as the banker is concerned, they don't follow the printed promisor notes. They have their own pro forma and they have it only that way. That is the debtor executing it in favor of the guarantor and the guarantor endorsing it or transferring it in favor of the banker by delivering the demand promisor note to the banker. That's how the triumvirate relationship comes into play. Debtor is answerable to the guarantor, and the debtor and the guarantor endorsing it in favor of the bank by giving delivery of the document, where the debtor and guarantor are jointly and severally liable to the bank concerned, the endorsee. Normally, as advocates, we take a plea, sir, saying, sir, as far as we try to take the technical defense of saying, sir, there is no privity of contract. I am no way concerned with the bank. I am only concerned with the promisee. But please remember, it's something like a hanging sentence where you say hang until he is dead. Already the debtor is dead by endorsing it in favor of the guarantor, and the guarantor is making it over to the bank by way of endorsement or on the reverse by assignment, and the assignment note is being given to the debtor, and where all the other three people come into a contractual relationship. And here the maxim of nemo dat quod non habet does not apply. Why? Because the bank comes into possession of the demand promisor note as a holder in due course. Are you able to understand the meaning of promisor note, please? Next one is we define what is called bill of exchange. Bill of exchange is defined as instruments, instruments in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to the holder of a certain portion of, here it is said, is defined as an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of the certain person or to the bearer of the instrument. Here, mostly this bill of exchange has almost gone out now. I think most of you know who are dealing with commercial transactions. Nowadays, we are in an era of information technology. When we buy anything on hire purchase, or let us say we order for certain goods, and when we order for certain goods, you are supposed to pay the advance, and for the rest of the money, You are given 3 months time or 90 days time as credit to prepay the money. One of the easiest way of dealing with such scenarios is here instead of that is why it is said containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money or do an order of a certain person or to the bearer of an instrument. So in a bill of exchange, what happens is there are three persons. One is called the maker, or uh, is called the first party. The second person is the person who is to receive the money, and the third person is the person who pays the money. That is drawer, drawee, as well as payee. Here, the drawee does not make the drawee does not make the payment. What he does is the drawer. What he does is he directs the third person, sir. This man is a respectable person. He has got a good integrity. He has got good solvency. He is not in a position to pay the money which is for the ordered goods. Please, you pay the money within 90 days, and some third party undertakes the liability to pay on behalf of that person, and 90 days grace time is given to make the payment. Here it is said goods can be goods can be paid in cash or when goods are sold or brought to credit. The payment is deferred to a future date, where that is a situation. Normally, the firm relies on the party to make payment of the due date, but in some cases, to avoid any possibility of delay or default, which the buyer assures the seller that the payment shall be made before the due date. Then in India, instruments of credit has been in the form, and that is why sometimes what you have is bill discounting facility that is granted by the banks. Here, what happens is under these bills, whatever bills are submitted for payment, the bank assures payment, and then towards the loan amount, it pays the money, and later date 90 days period is given before which the payment has to be made. Some third party assures payment, and he assures the credit that the credit will be honored, and it will be honored and it will be paid on the due date. And please remember, no business transaction takes place without credit being given. Credit is the order of the day as far as business transactions are concerned. If no one gives you credit, please remember that will be the last day for you in the business. So that is the reason I think the understanding which I have and the act as is 90 days period is given. What the maker does is he wants payment for the goods that are delivered. For that, he orders a third party, sir, whatever is due by B, you kindly make the payment within 90 days and assure that the monetary liability will be honored. He signs the document and endorses and directs the payee, payee to make the payee to make the payment within 90 days period. And here, goods are supplied on credit. Maker asks a certain person other than the uh, drawee to drawer rather, I'm sorry, to make the payment. The other person makes the payment, and then the bill of exchange is made. Thereby, there's a contractual relationship brought about by the third person and the debtor, that in case the debtor does not pay, by enforcing that particular bill which has been given, 3 months time has been given for payment. If the goods are not paid, the price is not paid, then the person who makes the payment on behalf of the person who delivers it, he can recover that money from the debtor or from the person who receives the good. This is the essence of bill of exchange. In India, it has been that is in one of the cases it is said presented for payment within time, and then the question is it should be signed by the maker. It should be delivered to the person who has to make the payment. 90 days credit will have to be given. Time limit is also fixed for payment. Immediately after the 90 days period expires, the person who makes the payment on behalf of the person who receives the goods, he is liable, he is entitled to recover that money, whatever he has paid. In other words, credit arrangements are ensured through bills of exchange. But please remember, now we don't have bills of exchange at all, which is practice. Nowadays, we are in the era of PDCs, or what is called post-dated checks. Post-dated checks are taken beforehand and on the due date, which is mentioned. That is, before the expiry of 90 days, it has to be honored. And then whenever it is banked in the end, as submitted for encashment, funds must be made available, credit facilities are given. But now the banker himself is taking upon the responsibility, what is called payment of the bills, but it has to be ensured by the person who delivers the goods to say, sir, the payment or the it can be ensured by the debtor himself or the person who receives the goods, sir, see that the bills are paid, it is discounted with your whatever interest you are entitled to it, and please make the payment within 90 days based on that bill. This is what is called bills of exchange. But please remember, don't attach any importance to bills of exchange today, because nowadays we have lot of facilities that are given by the bank. Bill discounting facility is also there. You need not make the payment. Bank makes the payment. Don't think the bank is going to pay from its pocket. Whatever the bank pays to honor a bill, to respect the bill, that amount will be added onto your loan account and recovered from you under the BD facility, or what is called bill discounting facility. So credit is normally given in the wholesale market. If no one gives you credit, please remember that the last day in the wholesale business runs purely on credit, and there must be mutual respect for each other. And even when a person delivers the goods on faith and trust, you should also see that you honor it, you make the payment, and from the person who is directed to make the payment on behalf of the maker, that is a person who is to receive the payment, then there is a contractual relationship brought about by this particular document. Are you able to follow, please? Please remember, bills of exchange today is out of vogue. It is not in existence. It was mostly, this bills of exchange was evolved during the Sindhis who migrated from Pakistan. They were they were delivering goods or entering to such transactions based on undis, as they call it, HUNDIS, where you don't make the payment, but you ask a third party to make the payment, and it is signed by you. The maker gives the authority that you make the payment. I shall try to make over that amount by that facility which is given. That's how a contractual relationship is brought about when the goods are delivered on credit. That is what is called bills of exchange. So in a bills of exchange, how many parties are there? Sir? In promissory note, how many parties are there? Two parties. Who are those two parties? One called the promisor and another called the promisor. One called the creditor and another called the debtor. But as far as bills of exchange is concerned, it comprises of three parties. Who, sir? Drawer, drawee, and the payee. The question is, payment is not made by the drawer. Payment is made by the payee. Payee pays on behalf of whom? Payee pays on behalf of the drawer. And the amount is paid to whom? The amount is paid to the drawee. Why? Within what period? Within 90 days. 90 days is the period of credit that is given. And once before the 90 days comes to an end, that amount is paid by the bank on behalf of the debtor to the creditor, and that is appropriated towards the sale proceeds. And then the bank has got the option, whatever amount has been paid, it has to be reimbursed by the debtor on whose behalf it has paid. So in other words, the maker or the question is, the drawee will have to authorize the bank on behalf of the drawer, sir, whatever payments have to be made, you make the payment on a certain date and within a certain date based on the bill of exchange. And then after you make the payment, you have got a right of stepping into my shoes and then recovering that money, which I could have done or I would have done based on the credit transactions interceived myself and the debtor. This is called bills of exchange. Bills of exchange comprises of three parties. One called the maker, another called the person who has to receive the payment, and third one is the person who has to make the payment. Drawer, drawee, and payee. That is the essence of a bill of exchange. In promissory note, how many parties are there? Two parties. One called the promisor and another called the promisee. But in a bill of exchange, there are three parties. One called the maker, that is the drawee. Another called the drawer, the person who has to make the payment, and payee, another person who pays on the directions of the maker or on the directions of the debtor who makes the payment is called the payee. So a triumvirate relationship exists between the drawer, maker, drawer, as well as the payee. First, there is a transaction, a credit transaction. 90 days period is given. A bill is drawn, directing a third person to make the payment for the delivery, and it's signed by the debtor, authorizing the bank to make the payment. And once the bank makes a payment, it has got a right of stepping into the shoes of the creditor and recovering that money which it has paid on behalf of the debtor. This is the essence of a bill of exchange. And bill of exchange consists of three parties: one called the maker, one called the dryer, and another is called the payee. Prompts are not only two parties, promisor and promisee, but bill of exchange, three parties. One called the drawer, another called the drawee, and another called the pay. This is bill of exchange. Third instrument which all of us know, which we deal with almost every day, that is called checks. Checks is a direction to the bank to pay a certain sum of money, and the check is normally drawn in the name of a bank where you have an account. It is properly dated, and the person to whom the money has to be paid will be clearly mentioned. How much money has to be paid will be clearly mentioned. It will be in words as well as in figures, and duly signed by you, and also on the reverse also you sign, and here the check is issued. So what is the effect of a check, sir? Check is an unconditional request from the person who is the drawer to the payee, and when it is drawn in the name of a particular bank with a particular date and with a particular amount mentioned in words as well as in figures, that payment has to be made by the payee. How many parties are there in a check, sir? Three parties. One is called the drawer, who issues the check. One is called the drawee, who has to receive the check. And one is called the payee. Payee is the person, is the bank which makes the payment. Are you able to understand, please? So three parties are there in a check. First, it is drawn in the name of a bank with a particular date and the person to whom the payment has to be made, then the amount which has to be paid, and in figures also to be mentioned and duly signed by the person who is the account holder. So there are three parties called drawer, drawee, and payee. A contractual relationship is brought about between the drawer, drawee, and the payee. Of course, payee is not responsible. Suppose there are no funds into the account, the payee will not pay. He will only return the check as dishonored due to various reasons it may be. So that is as far as a check is concerned. So the distinction between a check and a promissory note is promissory note comprises of only two parties. One is called the promisor and another is called the promisee. And it is relating to a money transaction between the parties. But as far as the bill of exchange is concerned, it comprises of three parties: drawer, drawee, and the payee. In a bill of exchange, the third party will be directed to pay a certain sum of money to the to the drawer, and the drawer makes that payment to the drawer as far as the business commitments are concerned. Normally, it is signed by all the parties. It is also informed, and 90 days period credit is given for the supply of goods. Goods are supplied on credit. This arises in the case of supply of goods alone. So these are the three instruments which are prevalent under Section 4 and defined separately. And that is defined under Section 4. Then, what do you mean by a holder? Please remember, there are different types of instruments. Here, from especially a check, we have to be very, very careful. Why? Because there are different types of checks which are issued. One is a bearer check or a self check. Another is a account payee check, and another check called only and co. That means only to the account concerned. Please remember, as far as two things are concerned, account payee checks are only to a particular company and co. You write and put two process there. That means it has to be paid only to that person alone and not to any other person. And normally, the amount which is mentioned in the cross check is not paid across the counter. You have to present the check in your banker, you send it for encashment, and then when the amounts come, then alone the payment will be made, not otherwise. Even if you know the banker very well, cross checks, normally the banker is not authorized to pay you the cash. Though you are the person entitled for it, the banker will not pay, because cross check is paid only to the person who is entitled to that amount and proper identification, and that is subject to encashment, subject to being presented to the bank for encashment or for trial or whatever it is, but it will not be paid across the counter. But a bearer check is more dangerous. Why I tell you? Because you draw a bearer check, self or bearer. Self or bearer is, suppose let us say my admin, Mr. Kalyan, is carrying a bearer check with him. He has issued that bearer check, and let us say he drops it on the road. I find that bearer check. What I do is I take that bearer check, go to the bank, whichever bank or whichever branch it is, and then present that check for payment. The banker is bound to make the payment because it is a self check, and I am the bearer as far as the check is concerned. But most of the banks, what they do is they uh, inform the drawer, sir, your check has come to us. You have issued a check for 50,000 rupees. Have you issued to the correct person? Is it a cross check or is it a bearer check? Then suppose I tell him, sir, I only made a bearer check. Then in that case, anyone can draw the money on presentment of the check. But please remember, nowadays we have the closed circuit TVs also, where who is the person is who is receiving the check, who is the person who is receiving the payment, his identity can be easily traced. But please beware that as far as possible, don't issue bearer checks. Bearer checks are the most dangerous checks which you issue. Anyone can take it and then encash it. So the question is, as far as possible, bearer check should not be issued as far as possible. If you have got the time, you go yourself and draw the money, but don't give it to your clerk or don't give it to your gumasta to go and draw the money. Because sometimes he plays a fraud, you will be made liable because the account belongs to you. So you have to be very, very careful. So the distinction between a cross check and a bearer check is cross check cannot be paid across the counter, but it can be paid only by submitting it for encashment to the banker for collection. And if the funds are not available, the check will be returned back with a bank memo with whatever endorsement the banker likes. But as far as bearer check is concerned, when it is drawn in the name of self or bearer, any bearer who finds a check found on the road, he can go to the bank and draw the money. And please remember, nowadays the banks are taking the precautions. Whenever you find a bearer check, they take your signature on the reverse and also take your phone number also so that you can be contacted. I think this is a introduction which I wanted to give it to you as far as the Negotiable Instruments Act is concerned. I want to take a considerable period for going to the other subjects because these are the basics which you have to know. Again, only thing is by way of repetition, promise and note is payment and pay is a payment made on demand or order. Promise and note is a document which is on payment on order or demand. A demand promise and note is a promise and note which is a demand which is executed by the by debtor in favor of the guarantor and endorse it in favor of the third person by way of transfer. Check and bill of exchange is made by the drawer made by the drawer authorizing a third party to make the payment, and third party makes the payment. He steps into the shoes of the person on whose behalf it has paid. And 90 days normally it is all credit purchases which are made, and for the delivery of goods and the payment of the price, the third party makes the payment. A date is fixed, and it is also signed and delivered to the person who has to make the payment. And a certain sum of money, the sum has to be clearly mentioned, clearly, without any interpretations, without any corrections, without any alterations. Because sometimes alterations or deletions or overwriting vitiates the document. So these are the, and check, of course, I told you, it comprises of two or three parties, one called the drawer, another called the drawee, and another called the payee. A check is normally drawn in the name of the bank with whom you have got an account. It is drawn in favor of a person who is entitled to draw the money. It is properly dated. It is signed by the person who issues the check, and the payee to whom it is presented for payment has to honor the instrument if there are funds available, and then it will be debited to the account of the customer. And then these are the things which happens as far as checks are concerned. I also told you that checks are of two types. One is called a bearer check, and another is called an account payee check. As far as account payee check is concerned, it cannot be drawn across the counter. You have to submit it to your banker for encashment and then draw the money. But as far as bearer checks are concerned, it can be drawn by any person who comes into possession of that particular check. This is the introduction which I wanted to give it to you, only dealing with section 4, giving the scope of Negotiable Instruments Act, what is contained in the Negotiable Instruments Act, what is meant by promise and note, what is meant by bill of exchange, and what is meant by a check. In the next class, that is tomorrow, I shall deal with the rest of it. Thank you. We now the interaction period starts. Yes, Mr. Nagachandram.
Are you able to get it?
Yes.
1 minute. He's not able to get it. 1 minute. 1 minute. 1 minute. 1 minute. I linked in the book. Go ahead, sir. Go ahead, sir.
గురువు గారికి నమస్కారం.
నమస్కారం అండి నాగచంద్రం గారు.
సార్ ఇప్పుడు ఈ ఎన్ఐ యాక్ట్ లో ఇప్పుడు కొత్త సెక్షన్ ప్రకారంగా 223 200 సార్.
Yes, sir, it only consists of
200 సిఆర్పిసి కింద వేసేది సార్ మనం.
ఏమండి
ఇదివరకు సిఆర్పిసి 200 కింద వేసేది మనం ఫైల్ చేసేది. ఇప్పుడు 223 అంటున్నారు. అక్యూజ్డ్ కు నోటీస్ ఇచ్చిన తర్వాతనే మీకు నంబర్ ఇస్తామంటున్నారు. 2 కేసెస్ పెండింగ్ ఉన్నాయి సార్.
Exactly, sir. The question is, once an NI case is filed, it is numbered as STCNI. So once it is numbered as STCNI, then the question is notice to the accused is compulsory. There is no doubt about it. But the question is, even if most of the people are converting it to 420, please remember, once NI Act is there, 420 is not attracted. NI Act, there's a particular procedure which is to be followed from section 138 to 148 or 149 of the NI Act. Previously, the NI Act comprised of only 142 sections. Today, we have some 6 sections that are added. We'll come to that as and when we come. But when you file a private complaint, you file it under 138. Let us say you file it under 138. But please remember, all complaints under the NI Act is filed only under 138 NI Act. Am I making myself clear to you, please? All complaints are filed under 138 NI Act. 200 is not attracted. You can file, no one doubts you. But when you file a private complaint, notice has to go to the accused, irrespective of your complaint being there. But normally what happens is there is one section called section 157, where 156.3, I'm sorry, 156.3 is you ask the court to send it to the police officer for investigation. Then the police officer investigates into the matter, and then under 174 he files what is called the IR, what is called the investigation report. And once the investigation report is filed, the proceedings start. But please remember, it is very, very dangerous to file it under 200 because 200 is not attracted as far as NI Act is concerned. Mostly, it is my humble opinion. So notice has to be given, sir. There is absolutely no dispensing with notice.
Yes, sir. Okay, sir. Okay, sir.
Next, please.
Mr. Srinivas Reddy.
చెప్పండి రెడ్డి గారు. Yes.
Mr. Srinivas Reddy garu, please.
Mr. Srinivas Reddy.
All right, Muralidhar garu, please go ahead, sir.
Good evening, sir.
Good evening, Mr. Muralidhar.
Sir, the promissory note is a separate, we can take action on the just promissory note in the court.
Sir.
No need of writing.
Sir. As far as promissory note is concerned, promissory note without a receipt is you cannot enforce it, sir. Promissory note comprises of 2 parts, promissory note and receipt. But what people now they are doing is most of the villages and people even in the urban areas, they think that getting it written on a bond paper of 50 rupees or 10 rupees or whatever it is, it has got more sanctity than a printed promissory note or a typed promissory note. Please bear it in mind. The wording that is used in the promissory note is the same whether you type it on a bond paper or whether you type it on a printed form or in a typed paper. But promissory note for all of us comprises only of 2 parts, promissory note and receipt. Because tomorrow what happens is, suppose that man denies a consideration, the only point on which you can pin up the other side is, sir, you have already received the money. Only after receiving the money, you have promised to make the payment. Promissory note cannot be only on one promissory note. Receipt also has to be there, sir. But only the bankers are exempted. That's why I told you they name it as demand promissory note. What they do is the debtor executes it in favor of the guarantor, and the guarantor by delivery of the promissory note to the banker and saying made over to State Bank of India, whichever branch it may be, putting his signature and giving notice to the debtor that I made it over to the bank and from tomorrow onwards the bank will be your creditor. That is a speciality of negotiable instruments, sir. It can be endorsed, it can be negotiated, it can be transferred, but it has to be in writing, and the debtor has to be given notice that it has been transferred. Are you able to follow, please?
Yes, sir. Then issuing a check, dryer, no need of taking promissory note, isn't it?
But
Because
one thing, sir. I would like to clarify. I'd like to clarify. Most of the cases have failed because first and foremost is when you file a complaint under 138, it is subject to section 142. There must be a pre-existing monetary or pecuniary liability towards which a check has been given, and when the check presented for payment has got bounced, and so the primary liability has not been, the pre-existing liability has not been honored, the check has got dishonored, so the accused is liable to be punished as per law. So it's subject to section 142, sir.
That's what I'm saying.
So
Just
pre-existing monetary liability should be there. So promissory note or some document or some receipt or something like that to show the relationship of debtor and creditor.
So, promissory note with the receipt, can we directly file the case? No need of check.
You can file a civil case, but your case will fail if you come.
Not under 138.
138, you must satisfy 142.
142, yes. Check has to be given and
monetary liability.
Well, I am now contesting a case.
Yeah.
I filed a discharge petition before the giving a charges framed.
Right.
For the judgment.
Yeah.
As it was argued that in STC cases, discharge can't be given. We have to go for a quash of the FIR.
You have to go only to the High Court, sir.
Yeah, but under 258, old one now, 281 new BNSS. In a summons cases, this is a summons case, sir.
Yes,
isn't it, sir?
SCC.
Magistrate can stop the proceeding if he is satisfied that it is not properly filed by the complainant. I am also, shall I try when the magistrate discharges, can I file again under 281 because I have not heard it that time 281. Can I again file the petition under 281?
For what?
Because my one of the contents my case of why is out of 3 accused, 2 were not served.
Right.
The notice required. Number 1. Number 2, there was an FIR against the complainant before 3 months in the police station that he went and threatened the accused.
Right.
After that, he sent it to a wrong address.
Right.
Knowing well that he knows the house of the accused.
Right. Right.
These are my contents, my grounds of fight. And most thing is 142, which says cognizance of the case. 142 section B. It has to be, notice has to be given within 15 days. And within a month of the, after notice, after 15 days, within a month, cause of action, he should file a case. Right. He filed a case after 1.5 months.
Right.
That was my concern. Provisions are not maintained. Compulsory provisions of a special act.
If the mandatory provisions are not kept up, then the question of it results in the dismissal of the complaint. No, but there is a provision 143 which says delay also can be condoned in case the complaint is not filed within time.
That has to be done before my argument, sir.
That is that. You can't do it now. You can't do it now.
That was not done. That was not done by the complainant.
If it is not done, it goes.
That was my argument.
Because this section was not there earlier. These sections have come only recently in 2021 or 22, if I'm correct. 143, 143A, 144, 145, 146, 147, and 148. Now they are provided for what is called a provision for interim compensation also. And then if you file an appeal also, 20% of the check amount should be deposited.
Yes, sir. Thank you.
And even evidence affidavit can be filed in STC cases. That also has been provided.
Evidence, sir?
Evidence affidavit, or what you filed it in the civil court.
Yes.
Yeah.
So now, sir, are we now following BNSS in the old cases?
No, sir, it's not retrospective. It's only prospective, effective from 1/7.
1/7. No. Old cases.
Old law only applies.
Old apply. But I found a Rajasthan High Court said, High Court, you file under BNSS, even old case also, and
no, you have to see the savings clause, sir. Savings clause, it will say whether it is retrospective or prospective. Normally, the understanding is all laws are supposed to be only prospective or not retrospective. And the implementation date was effective from 1/7. If you see the preamble.
1/7, okay. I'm talking about old cases.
Old cases here in Telangana, they're following the old law only for the older cases. But new cases, they follow the BNSS.
New cases, sir. Okay, sir. But when you file any petition in an old case now, what has to be filed under BNSS or what?
See, mentioning wrong sections will not vitiate the complaint or vitiate the petition. But one thing is this, better to be safe side, because to be frank, with due respects to the courts, they don't have the IQ. Or he said now new section so and so.
Yes, sir. Thank you, sir.
Welcome.
Ms. Gausia.
Sir, is the bill of exchange is in existence, sir? We
now it's almost gone out of circulation, madam. Because now we are depending mostly on PDCs, post-dated checks. Bills of exchange have almost been extinct. They are not prevalent today. But it is contained in the...
What is Hundi, sir?
Hundi is same thing, like bill of exchange only, madam. Where a third party would ensure payment, and within 90 days the third party has to pay. Then the third party pays on behalf of the drawer, and on behalf of the person who has taken delivery of the goods, and then the third party gets reimbursed by claiming that amount from the person on whose behalf it has paid. That normally arises in bank transactions where the banker has the bill discounting facility. The banker makes the payment on behalf of the customer, and whatever amounts have been paid, it will be debited to the loan account, and from the loan account it will be recovered from the person who is the customer. Are you able to understand, please? Normally it applies to credit transactions where 90 days period is given for payment, though the delivery is made. Am I clear?
One more time.
Madam, a third party undertakes the liability, madam, where the payment is not made by the person who has received the goods, and the third party makes the payment on behalf of the person who receives the goods, and within a period of 90 days on the presentment of the bill, and whatever payment has been made, it will be recovered from the person on whose behalf it has paid. Are you able to understand, madam? That is called the bill discounting facility. Are you able to understand, Mrs. Gausia? Yes?
Yes, sir. One more doubt, sir.
Yeah.
Sir, can the magistrate forward the complaint made under section 138 of the NI Act, sir?
Under 156(3), you can forward it to the IO, and IO has to investigate the matter. And 174 the IR was to be filed. That is, the investigation report has to be filed. But in very rare cases, they do it. But normally, I tell you why. I know why you are asking that question, because the police will threaten the person and then recover the money. Because nowadays, police is acting like a parallel court. And your new BNSS also is mostly tilted towards the police, because the investigation process, if you have seen, previously remand was for 14 days. Now the remand has been extended to 30 days. First instance itself, 30 days remand can be granted on the request of the police. It is mostly tilted more in favor of the police.
All right, Mr. Satya.
Sir, good evening, sir.
Good evening, Mr. Satya.
Sir, how much amount of this revenue stamp must be fixed on the
Sir, there is no limit, sir. Only thing is, it should have a revenue stamp. If you go by the table for every about 1,000 this much and all, even if you have fixed 2 or 3 revenue stamps, it will suffice. But please remember, there is a way of signing also. It should start from the beginning of the margin and then end with the end of the stamp, so that there are no interpolations or corrections or alterations, sir. And there is no prescribed limit, sir.
Sir, thank you, sir. Thank you, sir.
Anybody else?
Sir, this order given by the Supreme Court on 16/4/2021, sir, regarding all latest amendments for whatever directions followed by, it has given on 16/4/21 of Supreme Court of India.
Yeah.
That orders now that we have to follow, sir. It is practice of directions given by High Court of Delhi,
Sir.
which referred that as per the complaints of the order of the Honorable Supreme Court of India dated 16/4/21.
Yeah.
regarding that, there are some amendments. All these things, 143A, 140.
New sections have come.
Yes, sir. That order is important for the advocates to try and enact cases.
You're right, sir. But one thing is this.
Just for the information, sir.
But BNSS, I've seen, sir, there is a saving clause that as far as old cases are concerned, the new act does not apply. It applies only from 1/7/24. It is not retrospective unless it is provided in the act. But it
Yes,
is,
sir. These are not prospective only. My point is, when you file any petition now, present, for any...
no, if you file presently, only the old act applies because the case dates back to that. Except I know what you are referring to. You are referring to that Vinita Sharma's case in Hindu law of succession, where the Supreme Court, knowingly or unknowingly, I do not know, they said it's retrospective as well as prospective. Unless you must see the savings clause. But I am a vociferous critic of the new law, sir. I'm sorry. It is mostly treated.
Now, at least we can put both the case. We can write the CRPs under so and so,
You can write
BNS under such.
But we have got a ruling also of the Supreme Court also, which says the courts are not holding, operating trapdoors to catch the unwary. Even if you mention a wrong provision, court can correct it and interpret it.
Yes, now it's going to be a big problem, sir, because one of the judges were telling all these years, 1973 CRP was amended.
Yeah.
Now, after 50 years, several judgments were given by Supreme Court and High Court. They're all gone now. It is taking interpretation or taking from their case laws. It's a big problem now for the new acts.
And for your information, this has been challenged in the Supreme Court, the present acts.
Now, okay. Now,
so
let us see what
the Supreme Court is inclined, because you know the rulings of the Supreme Court now, Supreme Court is against the government. So long as
the Chief Justice of India,
yeah, so long as
the Chief has praised that, Chandrachud has appreciated, he praised the new laws.
Sir, he has praised it, sir. But one thing, writing will be entirely different.
Yes, sir. Now we have to arguments will
if
go
you
on.
See the latest judgment yesterday, I've read the paper. See, Shahbanu's case has been given a go by now. That is, as far as maintenance is concerned, Muslim woman is entitled for maintenance till she gets remarried. Yes. So Shahbanu's case has been implicitly overruled. But Shahbanu's case, if you have seen, it is the same judgment rendered by Justice Chandrachud. That is his father. It has now been almost overruled. I think it has come in the paper. It has not been reported. A Muslim woman is entitled.
It has come, sir. I have also seen that. And that is triple talaq if we give. She is entitled for 125 CRPC maintenance.
Previously, under the Shahbanu's case, only the iddat period. That is 3 months period. But now, under the new enactment, what they have said is, till she gets remarried, she is entitled for maintenance.
Yes.
See how that's why it said in jurisprudence that justice varies according to the foot of the chancellor.
Yes, sir. Now it's all the problem to just to understand it. I do not know it's going to be a problem.
Sir, I'll quote one instance, sir. Here in Andhra Pradesh, Justice Seshasayana Reddy was there. He was asked to interpret regarding jurisdiction of under the NI Act. He just gave a conservative ruling saying that wherever the accused stays, the case has to be filed there. That was a case arising out of Guntur. Then subsequently, the matter was carried to the Supreme Court. Supreme Court has given 5 options: place of the complainant, place of the accused, name of the bank where the check is issued, name of the bank where it is presented for encashment, and the place from which it has been dishonored. 5 options have been given to you. So wherever the complainant stays or wherever his bank is there, it will give jurisdiction to that bank. So Seshasayana Reddy's judgment has been overruled. Overruled. So 5 options are given to you now.
Sheshasan Reddy was residing in my area when my DSP Nandyal.
Sir.
He's near that village. His house is there. Sheshasan Reddy.
Sir, he was the luckiest.
So he got a problem in his house also, which I solved.
Sir.
So he was very happy with it. He was in charge of the Kurnool district.
Yes,
as a High Court judge.
He was the luckiest person, sir. He was a law officer in Andhra Bank. And the question arose in his own case as to whether the standing as a law officer in Andhra Bank will hold good to become a High Court judge. But in his case, I don't know why they interpreted it by saying, even if you are a law officer, that period will be taken as in the period of standing. So you are entitled to become a High Court judge. And his wife is also now the chairman of the DRT now here in Hyderabad, Debt Recovery Tribunal.
Thank you, sir.
Right.
Mr. Sheikh.
Sir, good evening.
Good evening, Mr. Shruti Kirtan.
Sir, in the promissory note, there will be a witness sign, sir.
Yes.
If witness signs are not there, is there any problem, sir?
Even if witness is not there, it does not vitiate the document, sir. But we take the signature of witnesses so that the party may not deny execution, party may not deny consideration, party may not deny the day on which the document has been executed, and so on and so forth. That is the reason why witnesses' signatures are taken.
If it is not there, not a problem, sir.
Not necessarily, absolutely doesn't vitiate the document, sir.
Once again, sir, did not understand, sir.
Sir, the witnesses are absolutely not necessary. If the witnesses are taken, they will say that this is in the handwriting of so and so. It has been on a particular date, and the person has signed in our presence, and the money is received in our presence, and he executed the document, and there is execution and there is consideration. That is the reason why we take the signatures of witnesses. It is absolutely not necessary. It is not mandatory that witnesses should be there.
Okay, sir.
Thank you, Mr. Sheikh. What is the next question?
Sir, good evening, sir.
Good evening. చెప్పండి.
Sir, enact law. Enact law.
I have a request, sir. Please speak in English. Because, sir, I have a request to you. Please speak in English so other persons will understand. So many other people have come from other cities and states also. I'm not able to hear you, sir. Please speak loudly, sir.
One second.
Yes, Mr. Sheikh.
Sir, in enacts,
Yeah.
there is any chance for amendment of a complaint, sir?
No, sir. There is no provision in CRPC providing for amendments, sir. I'm sorry.
Okay, sir. But it is a quasi-criminal, sir.
Maybe even
Enacting.
quasi-criminal, there is no provision for amendment like CPC.
Please, sir. Thank you, sir.
Welcome.
Any other questions?
Please, please.
In case you cannot amend it, file a civil suit.
Okay, sir.
Yeah.
Thank you, sir.
Any other questions?
No, sir. Thank you, sir.
All right. Any more questions from any participants? Please go ahead. All right. Let's wind up for today. See you tomorrow again. Thank you very much. Bye-bye.